He says true.
2, you failed to report to the Jefferson County Probation Office since being on probation on March 31st of 2025. Were you arrested earlier on this, or was there a period of time that he did not report until he gets arrested? How long? You were supposed to report monthly.
Yes,
Yes.
sir.
And did you fail to do that?
Yes, sir.
When did you finally get arrested?
Um,
Do you remember?
I don't remember that.
I would. It would be
It was
important to me.
I got arrested on 3rd, October 3rd.
October. Okay.
2 arrests, 1 week, and a defendant who still thinks he can talk his way out. The judge has heard enough excuses. Now it's time for the truth to stand on its own. Watch closely, because Adrienne Jacob is about to learn what consequences really look like.
So you were supposed to report, you were placed on probation on March. So you would have had to report April, May, June, July, August, September, and then in October you get. So what's that, 7 months go by that you didn't report? Is that true? About? It's 6 or 7 months.
Yes, sir. Yes, sir.
Oh,
Yes, sir.
so is that allegation true and correct?
Yes, sir.
I'm going to stop at that.
Mhm.
Okay. Are you pleading true to allegations 1 and 2
Yes, sir.
of this motion to revoke probation voluntarily, knowingly, intelligently, and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced no less than 2, no more than 20 years confinement in prison, since this is a second-degree felony. Knowing, understanding, and appreciating all of that, do you insist on pleading true today to these violations?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true
Yes, sir.
to violations of probation.
Yes, sir.
Let's hold that in abeyance. Okay, go to 23 CR 1838. Again, does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
And again, you're under oath, sir. In summary, this motion filed on September 29th, 2025, as well as the previous motion, it states in this other case that on March 31st, 2025, the same day you were placed on probation in the aggravated assault with a deadly weapon, second-degree felony case, that you were sentenced to 2 years in this court in the state jail, probated for 5 years for burglary of a building. Is that true?
Yes, sir.
And allegations 1 and 2 are the same. That number 1, as before, the previous case, you committed the offense of theft on or about April 6, 2025 in Jefferson County, Texas, in violation of your probation condition 1 and 2. You failed to report to the Jefferson County Probation Office in violation of condition 4 of your probation supervision order by absconding in April and not being arrested until several months later. Are allegations 1 and 2 true as well as they were in this previous motion to revoke probation? Are you pleading true to allegations 1 and 2 as well in this case?
Yes, sir.
Are you doing that voluntarily, knowingly, intelligently, and because this is true,
Yes,
as
sir.
it is alleged? And again, do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation could be revoked in this case, and you could be just sentenced to no less than 180 days up to 2 years in the state jail.
Yes, sir.
Knowing that, do you insist on pleading true as well today?
Yes, sir.
I find you are pleading true voluntarily. In each of these cases, you understand and appreciate the consequences of pleading true and how that might make you vulnerable to revocations of these probation orders in each case. There is no agreement in each case?
Well, we come to you.
All right, go ahead.
Judge, I know that you just pointed out specifically the
Pre-sentence
time.
report? I'm going to look at the pre-sentence report while you're talking, okay?
I noticed you pointed out the time frame from the point that he got on probation to the point of this violation. But I think the court we're asking the court to take into consideration why it happened so fast. He was homeless, and talking to him, the object stolen, it's not like he was stealing a car or going stealing something major. To my understanding, it was buckets of water, not buckets, but bottles, cases of water. And the reason that he was getting that water that he was stealing, Judge, is that he was destitute and homeless at the time. At the time, he was destitute and homeless. And Judge, we're asking you to have mercy on him because, like I said, this is not a situation where you got a guy going into dealers and let's say he's stealing a bottle of cologne and resell it. And I totally get that. But this is a situation where he was destitute, he was homeless, and it was for his needs, his bodily needs, which would be water and cases of water. And Judge, I spoke with the prosecutor on this case as well. What I'm asking is that if you just give him one more shot, leave him on probation. I do believe to get him out of the hole that he's in terms of his economics, he will be able to get a job, right?
I have somewhere to stay down.
And he has a place to stay, and I believe some of his family members are gonna step up this time for him.
Yes.
So just looking at the nature, and he's accepted responsibility on the theft case.
Yes, sir.
On that theft case, Judge, if I'm not mistaken, and you can look at your file, I believe the misdemeanor court put him on probation for that theft. So in the misdemeanor court, they gave him probation. And who was your judge on that? That was Holmes.
Yeah.
Okay, yeah, I believe it was Judge Holmes.
Yes, sir.
So, Judge, what we're asking for is for you to continue him on supervision, move the case today, and consider his economic situation at the time. And that's why it happened so fast. And also consider the object that was stolen was not an object of, personal gratification. That's what he's telling me.
Yes.
At least that's what he told me.
Okay.
So that's what he told me.
But he was placed on probation for
Cases of law.
in 1411 that the defendant broke into the victim's truck, and that then he was armed with a knife and cut the man, is what he's alleged in this aggravated assault with a deadly weapon.
Yes, sir.
And
The other one was the MTLP for burglary of a building.
he was later arrested for the stabbing incident and indicted and placed on probation for that aggravated assault of March 31st of 2025. In September, they've released go again to Crystal Apartments on Gulfway Drive. Oh, 2 blocks away from the previous incident. And on September 5th and 23. And go to a theft that's reported where the victim reports that he stores industrial and commercial paint sprayers in a storage building, and surveillance video was acquired by police who show the defendant and another person stealing those items as they are in a Chevrolet sedan with no license plates on the front or rear of the car. They back into a spot. He and another person get out, steal the sprayers, then take off. And then Mr. Jacobs apparently is known by the Port Arthur Police Department, and he was recognized. And that apparently that there were two thefts of the sprayers on the same day at that same location. And police find the defendant, Mr. Jacobs, and he admits being involved with it. And so he's placed on probation in these two cases of aggravated assault and burglary of a building. He's placed on probation and given another chance in spite of the fact that he has how many prior felony convictions of burglaries and forgeries? How many, sir? Because I want to, there's so many, I want to know if you can recall how many you have been convicted
I
of.
can't, sir.
You can't even remember. What does that say? I know of 7. Burglaries of homes back to 91. A burglary of a habitation, somebody's home. 3 years later, you're convicted of another burglary of habitation. You get 15 years in prison. Then in 94, you're also sentenced burglary of a building, 15 years, because I guess it was enhanced because of the prior conviction. In 2000, another burglary of a building, 3 years in prison. Forgery in 07, a year in jail. Burglary of a building in 09, convicted, 6 years in prison. Then in 23, you were convicted of burglary of a building in January of 23. So those are the felonies. And let's not forget, I'm looking at a page full of misdemeanors, which are deep driving while license suspended, driving while intoxicated, theft, burglary of a building, of a vehicle, burglary of a vehicle. Anyway, so those are 4 convictions of misdemeanors, 7 convictions of felonies. And then now we have these 2 revocations. We're back. And it's as though everybody is spinning our wheels. I mean, you're not only continuing to commit a crime, and just not reporting. And hold on, let me just,
Yes, sir.
This, you keep talking about water, but the administrative hearing doesn't say that, Langston. It says that on April 6th of 2025, the date that this theft occurred, allegation 1 that he is admitted to, it states he committed theft on or about 4/6/25, stealing someone's wallet containing about $1,000 in cash, a debit card, and insurance cards at a local HEB grocery in Port Arthur.
And what do you mean?
He said, right, and Judge, I talked to him directly. He's saying that he had nothing to do with that. He's telling me that, didn't you tell me it was water?
Yes, sir.
I heard him correctly, Judge. He told me that it was water, that he was stealing because he was destitute and he needed bottles of water to drink. Is that what you told me? Judge, that's what he told me.
That's what the administrative hearing states is what this is. Okay. So now I've got a police report to look at your Sunday. On April 6th, there's on arrival on 4/6 at 21 at 9 p.m. Officers respond to Gulfway Drive at the HEB. Made contact with a manager who advised me one of the customers had her wallet stolen. I watched the video footage from the store, and then the video shows a male black approaching the victim near the produce area. She had her wallet on top of her cart. The suspect is observed walking toward her shopping cart as she's getting some produce. Facing away from the shopping cart, the suspect reaches for the wallet, which is on top of the shopping cart, and and then conceals it in the pocket of his sweatshirt. The suspect left the store shortly after, got in a passenger front seat of a dark green Chevy Trailblazer with no front license plate. The victim that are advised that I was advised the victim had $1,000 in cash or debit card as well as an insurance card for her children. She did wish to press charges. I spoke with the manager. Manager advised that the video had already been tagged, and then that's all it says on that. On April 8th, 2 days later, Detective Thomason with Port Arthur PD receives the case for follow-up investigation about the HEB theft. Let's see. The surveillance was played, captures the suspect taking the wallet, provided me Ramirez provided me a video and printout of the transaction. The name, let's see. The surveillance was played back. It captured the suspect taking the wallet. The suspect is a light complected African American with short hair. The same male bought items and used a card. Investigator Ramirez provided me the video and a printout of the transaction with the male suspect. The name on the transaction is Adrienne Jacob. I am very familiar with Jacob. I've known him for many years through my employment as a police officer at the city. I personally filed many cases against him. I reviewed the video. There is no doubt the suspect is Jacob, not only by his face, but he has a distinctive limp and is noticeably bow-legged. All right.
So you told me that it was water, right? So I guess the question the judge is raising is that based upon what he read, was that you?
Are you pleading true to these or not?
Yes, sir. Yes, sir.
You pleading true? He said he pleading true to still.
All right. Well, then you can't say I'm guilty, but I didn't do it.
Yes.
So you're saying that you're
Yes,
guilty?
sir.
He's saying he's guilty. Judge, I'm not misremembering. He told me it was water. That's what he told me.
That's well, you can see it's not a necessity of life here. This
I'm just doing what he told me.
I know. I know what you're saying, but we're going to clear the record up.
Yeah.
It's somebody's wallet and ID was used, and that was used to forge and commit theft. That's on that case, and then we have the burglary of a building matter. But so the defendant has pleaded true in each of these cases and admitted culpability. So the question is, what do we do in the aggravated assault? He is looking at no less than 2 nor more than 20 years confinement in prison. I think there was a loss of $700, wasn't it?
Your Honor, in the burglary of a building, it was actually $7,000.
Was $7,000?
Yes, Your Honor.
But in this one, the wallet contained approximately $1,000 in cash.
Yes, sir. And he's currently, I believe, on probation and misdemeanor court for that offense.
Well, how does he pay it back if he goes to prison for 20 years?
And Your Honor, our recommendation, and we normally wouldn't do this, but he did cooperate and had testified recently in a case for the state involving a serious offense, would be to revoke him on the aggravated assault, keep him on a straight probation.
How can I do that?
Well, it'd be then to keep him on the deferred there for the ag assault and sanction him to the max. But
So you want to just sanction him? What would be the sanction?
the 180 days.
I mean, I'll take all of that into account, but no, I'm not. With his splendid and rich criminal history and continued, I mean, we're talking about aggravated assault with a deadly weapon here. We're cutting somebody with a knife but okay, we've got this second-degree felony and then this state jail felony. What are you saying?
Well, Judge, and piggybacking on what the state just said, one thing I'm asking you to give him credit for is that he apparently did testify
And he's going to be
And he-
rewarded.
for cooperation.
He will be rewarded and with what I have in mind, but I want to hear what your thoughts are.
You know, I would want us to continue on probation and give him a second
Okay.
shot. But
It's hard on something like this when we're talking about a aggravated nature and then the burglary of a building. But he knows that actions have consequences, and the court is going to treat him with and give him credit for the cooperation he made. The problem you have, though, is that you can cooperate all day long. And did he testify in a trial?
Yes, Your Honor.
See, the problem is that when his all of these prior convictions come out, the jury can't show a lot of credibility to someone because all of that comes out. And the law states that the jury can consider prior convictions against the credibility of someone so that their statements have less value of believability than they would otherwise by somebody who's doesn't have convictions of felonies. And so you may have helped, but I can guarantee you, I know how juries are. If all of these felonies came out, and maybe they didn't, maybe the other side didn't bring them out. And if they didn't, then they don't know about it. But I know it. And it would only make sense that the defense attorney would at least challenge his criminal history in front of the jury and then argue that he's not worth credible belief because the law says that can be taken into account.
Judge, I apologize, but actually can't give me another chance.
Sir, you've had 7 or 8 separate
Yes.
chances here. We talked about how many
Yes, sir.
prior felonies, 7, and then misdemeanors, and then here we're still committing crimes. All right, anything else to add? And the court is going to take into account your cooperation. I'm going to find that there is sufficient evidence supporting each of these motions to revoke probation in cause numbers 1411 and 1831 to grant the motions by a preponderance of the evidence or greater, as the defendant has pleaded true voluntarily, knowingly, intelligently to the offenses alleged or the allegations of violations. Number one, in each case, committing the offense of theft on or about April 6, 2025, and we cleared up what that was about.
Yes.
It wasn't water. It was committing the theft of somebody's wallet and money of $1,000 and ID. And then allegation number 2, failing to report as the defendant was placed on probation and never reported, and for probation as ordered. And thus, those are violations that he has admitted to. They're proven by preponderance of the evidence or greater. And these motions, the motion to revoke unadjudicated probation in 23 CR 1411 is hereby granted. And the motion to revoke probation in 23 CR 1838 is also hereby granted. So your probations are revoked in each case. In this first case, 1411, where you were placed on 10 years deferred or unadjudicated probation. Earlier in that case, you pleaded guilty to that second-degree felony voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, even though that case was that final finding of conviction and sentencing of confinement up to 20 years was deferred. That deferred probation has been hereby revoked by this court based upon these violations of probation. You were hereby found guilty beyond a reasonable doubt of that underlying offense, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. And you will be given credit for all time you've served. And there's an affirmative finding that a deadly weapon, namely a knife, was used in that offense. In 23 CR 1838, your probation has hereby been revoked in that state jail felony of burglary of a building where you were sentenced to 2 years in the state jail. That was probated for 5 years. And your probation in this burglary of a building case in 1838 is revoked, and you were hereby sentenced to confinement in the state jail for 180 days. These two sentences shall run concurrently. You understand what has happened today?
Yes,
You've
sir.
been given the minimum sentences because of your assistance to law enforcement.
Yes.
The order also shall reflect in cause number 1838, the 180-day sentence, restitution is ordered and the judgment in the amount of $7,000. That's what was ordered in the first place. Restitution will continue. We're going to take care of victims, and that will be part of the judgment. Do you understand what has happened today, sir?
Yes, sir.
You did get reimbursed for your cooperation
Yes, sir.
that the state claims was helpful.
Yes, sir.
But still, you have to atone for the wrongful actions that you made. And I
Thanks.
fashioned a method that shows award. But please learn from all of these. These are now 2 more convictions. That means 9 felonies. That's far too much, sir. Your legacy in life should be doing good things, not being an habitual felon. Please do better. Langston, anything else you want to add? State,
Nothing from the state.
and we are in recess. Thank you. Appropriation.
Two arrests. 1 week. And a defendant who still thinks he can talk his way out. The judge has heard enough excuses, now it's time for the truth to stand on its own. Watch closely, because Adrienne Jacob is about to learn what consequences really look like.